At this point, just for some housekeeping, I'm going to ask all members to stay on mute. The presentations will be followed by a question and answer session, which I think will be more than adequate, give us more than adequate time. We're hoping for about 40 minutes. And we will, at that point, be asking you to raise your hands in the chat and we will acknowledge you. So at this point in time, I'm going to ask Nicole to kick us off.
Miss Rob, you know, me can't bother them people I do.
So who is the people that
Can I
this
get my
person
back?
can't bother with?
Can't bother, no.
I'm asking that person to go on mute. Okay, there you go, Nicole.
Thank you so much, Camille. Good morning, everyone. Thank you for joining us to talk about what Emil and I and Camille have stated is a very important issue, sexual harassment in the workplace, really. I'm going to bring up my screen, Camille. You can just confirm for me that you're seeing it.
I am definitely seeing it.
All right, let me try to. Excellent. So I'm going to talk a little bit about, I'm going to give some statistics to start. And then I'm going to talk about the duty of the employer. And I'll talk a little bit about what a sexual harassment policy ought to entail. And then Emil will lead us in what he calls the fun stuff. He will delve into the definition of sexual harassment. And he will also talk a little bit about the response that management can and really ought to have in response to this issue, when faced with this issue. There isn't a whole lot of empirical data on sexual harassment. As you would understand, it's something that people don't necessarily want to talk about. It is an area that is very significantly underreported. But in 1999, a survey was done among public sector employees, and 33% reported that they had been subject to sexual harassment. Only 13% reported that to someone. But at the same time, the vast majority, about 76%, thought that a worker guilty of sexual harassment should be disciplined. I'm going to give a little background to this study. And it was, I'm pulling from an article written by Jimmy Tindi Garukayo. This study happened because there were complaints to the Jamaica Civil Service Association about sexual harassment. And because of that, the Civil Service Association and the government of Jamaica came together, had a heads of agreement, formed a committee against sexual harassment in the workplace. And coming from that, they thought that a survey would be helpful to get perceptions and opinions and views from within the public sector. So we're seeing that this is a long-standing issue that has been facing us. Another study later on was done.
Sorry, Gay Cherie, please, right, please mute, okay.
Thank you so much, Camille. Tindigaru Kayo then did a study. The previous study, he only analyzed the data. But later on in 2005, he did a study on the private sector, government, and NGOs, and found that only 5 of 44 respondents had a sexual harassment policy, and all of them were non-state organizations. At the same time, the organization supported the enactment of sexual harassment laws. So he did an empirical study of sexual harassment in Jamaica, and that is what he found. He also found, he studied 13 government agencies, and at the time, 12 of them agreed that we should have laws. So it's not that there isn't an understanding that the issue is real and significant, and it's not that there also isn't an appreciation for the fact and a desire by people that we should have legislation on the issue. Very importantly, sexual harassment, it undermines equality at work because it affects the integrity and dignity and well-being of workers. It damages enterprises because our work relationships are affected, and as a result, it affects productivity, it impairs productivity. And the corollary of that, certainly the ILO believes that it also creates significant health, economic, and career costs for the victim, because victims suffer from sexual harassment. And I hasten to say that victims can either be male or female. We'll talk a little bit about them. There's a disproportionate leaning to females, but victims certainly can be either male or female, and the proposed legislation that we have is in fact gender neutral, as I believe it ought to be. So we've seen it's significant. We see that people want the legislation, but yet there is no legislation to mandate the employer to take immediate steps to address allegations. There's no penalty that is specified in law, and there is no law that clearly imposes a duty on the employer to ensure that steps are taken if sexual harassment comes to their attention. So the question then that comes to mind is, in the absence of legislation, does the employer really have a duty? What is the role of the employer? What is it that the employer is supposed to be doing in this situation? I would like to suggest to us today that even in the absence of legislation, there are implied duties. There are duties implied into the employment contract that are indispensable really to the functioning of the workplace and indispensable to a very sound and solid employer-employee relationship. So whether or not these are expressly stated in the employment agreement, there are implied duties of the employer. One such duty is the duty to provide a safe place of work. What does this mean? As far as is reasonably practicable, the employer has an implied duty to ensure that employees are safe and healthy. So one can argue then that a breach of duty to maintain a safe place of work could occur if the employer becomes aware that acts of sexual harassment are taking place within the workplace, the employee is harmed, whether it is physical harm or mental harm, and the employer does nothing to address the matter. So it begs another question. I know that you're thinking, well, what does sexual harassment have to do with a safe place of work? So I want to draw our attention, and this presentation is not case heavy. Emil and I sort of made that decision. But I do want to draw your attention to a case out of Trinidad, and it is Bank Employees Union and the Republic Bank Limited. It's from the Trinidad and Tobago Industrial Court. It's the case of Jalal Mohes, and there are not very many cases around this matter in the Caribbean. Of course, it stands to reason. The jurisprudence around this issue is very significantly underdeveloped. But Mohes was an auditing assistant, and he had worked with Republic Bank Limited for almost 25 years before he was dismissed. 3 women made allegations of sexual assault against him. One woman said that he came up behind her, he put his hand on her waist, he slapped her bottom, he ran his hand down her calf, and he said that that calf was nice and sexy. And there was also an allegation of kissing and other things. Mohes, interestingly, in his defense, said that a kiss of appreciation was common in the workplace. In other words, he said, but that's how we do things. So he was referring to the culture, and I know that's a question that probably will come up, particularly when Emil does his part of the presentation. Yet, the employer investigated the matter. Mohes was dismissed, and the court, in fact, upheld that dismissal. His Honor Cecil Bernard in the matter, I believe, made three very important points. First of all, he said that the actions of Mohes was within the corridor of dismissible conduct, which is a very, very important thing, because for the actions to be within that corridor, it means that it has to rise to a particular level. And most of us here know the term gross misconduct. It has to rise to a particular level to be within that framework. He also said that even when looking at this issue, the employer is required to look at the unwanted nature of the actions, the degree of seriousness of the conduct, and the relative position of the parties in the organization. So circumstances will vary. And of course, he's saying that you have to look at all of the circumstances. But those three factors, when we talk about sex, are you hearing me? I'm not sure why I was muted.
I'm hearing you now. You were muted for a bit, but I'm hearing you now. Please continue.
Thank you so much. So those three factors are extremely important. Additionally, His Honor confirmed, because this is basic and accepted, and as I said earlier, implied into the contract, that there is a common law obligation to provide a safe system of work. But he went on to say, because when we think about it, we sometimes think about protection against physical harm. But he went on to say that obligation may well extend to the provision of a work environment which is free of the threat or application of sexual coercion by one employee towards another. So what he's saying there is that this matter of sexual harassment is being brought into that understanding and that definition of a safe place of work. I'd like to put it to us that if it were put before our own courts, that it is quite likely that a similar position would be taken. In addition to that, there is the implied duty to maintain trust and confidence. Carla Harris Roper has described this as a duty that is synonymous with the principle of good industrial relations practice. She said so in her book, Commonwealth Caribbean Employment and Labor Law. And she actually mentioned a case where undue sexual influence was used by an employer, and it was considered a breach of the duty to maintain trust and confidence. What this says is that the employer is not to act in a way which would be likely to destroy or seriously damage the relationship of trust and confidence existing between the parties. And it is understood that any such action goes to the heart, the very heart of an employment contract. And so my thinking, and I think many labor practitioners would agree, that the employer then has to take reasonable care to prevent intimidation and abuse of an employee. Sexual harassment in many jurisdictions is framed in the context of anti-discrimination and discrimination law. And there is, in fact, an entire body of law on discrimination in employment. When I was in undergrad law, I did an entire course on discrimination in employment. We agree, and I said so earlier, it's an affront to human dignity. And at the same time, we will also, I think, appreciate that it disproportionately affects women. Now, in Jamaica, we talk about male marginalization, and that's really an important concept. The challenge I think that we have in Jamaica is that what we may wish to consider female superiority has really not translated to security of women and power within women and so on. And so we have this situation where women are disproportionately the victims. And therefore, I would like to suggest that we do require a gender responsive approach. We have a Charter of Rights in Jamaica, and Section 32 GNI speak to our right to equality before the law, as well as freedom from discrimination on the grounds of being male or female. Has this been tested in this context? As far as I know, it has not. But as I said, outside of this jurisdiction, certainly sexual harassment is grounded in the matter of discrimination. There is somebody who has a mic open and we're hearing you. Thank you so much. So I'd like to also suggest that a sexual harassment policy is extremely important. Boards, the management of organizations, the boards of organizations ought to consider this to be crucial in the organization, because the prevention of sexual harassment is important so that you can build a supportive workplace. And it must be clear in the workplace that sexual harassment must not be tolerated. Importantly, I read where, I think it's Professor Noel Cowell from UWI mentioned that sexual harassment most often occurs in the context of enabling organizational cultures and socio-cultural systems. Because it impacts on the organization so negatively, a policy that is clear is extremely important. So I'm going to spend just a little bit of time talking about what that policy should look like. It ought to have a very clear definition of what sexual harassment is. And I always recommend that examples, very specific examples, should be stated. We'll hear the definition later on, or a suggested definition, but you want to mention, so I don't want to get too much into that, but you want to talk about physical, the verbal, the non-verbal, the psychological, the entire gamut. You also want to define terms that might be unfamiliar to the staff. The document is for your staff to be familiar with and to understand. You'll see that the definition mentions terms like reasonableness, unwelcome behavior. What does that mean? You have to take a stab, you have to take an attempt, make an attempt at explaining those things, quid pro quo, and that sort of thing. It is important and helpful that it is clearly stated that workers have an entitlement to an environment that is free from sexual harassment. And as a corollary to that, that the company is going to adopt a zero tolerance policy or zero tolerance approach to that sort of thing. You also have to say that disciplinary action will be taken against the members of staff who perpetrate these acts. And it has to be clearly stated. Again, going back to the statistics that we're familiar with and the understanding of sexual harassment, there is often a power dynamic between the victim and the perpetrator. There's a vulnerability to the victim. So it's important that the policy sort of gives some comfort to the victim so that they understand that regardless of the level at which the perpetrator may be, they are still subject to the policy. And up to the board ought to be subject to the policy. The procedure for making the complaint ought to be very clear. And to this end, a form can be used. It is very helpful to HR to prepare a form so that when the individual presents, there is specific information that you can elicit from them in order to get the details of the matter. Investigative procedures ought to be clear. Supervisors need to know what they ought to do. Your HR needs to know what he or she, HR manager needs to know what he or she needs to do in the matter, in the process of investigation. The extent of applicable disciplinary measures should be stated. In the cases that I've read, for example, out of Canada, it becomes very clear that the matter of progressive discipline, which our labor code espouses in principle, still applies. And we saw so in the Mohes case as well, because there were factors that the court looked at that determined whether or not the penalty, the measure of discipline, was applicable in the circumstances. It is clear to me from reading that not all of the acts of sexual harassment, not all of the situations will necessarily amount to dismissal, but it is a possibility and it should be stated very clearly in the policy. It's a very sensitive issue, and so there has to be something said about the confidentiality of the matter. This is important, both with respect to the perpetrator and the victim. It should also state that internal mechanisms ought to be exhausted. In other words, there is an internal mechanism, go through it before going externally. Mention should also be made of what should happen in the event of a false claim, because we know this is not impossible, or in the event of retaliation by the perpetrator, because that too is a factor in these situations. And so I'm going to end by just giving a few more tips on the policy. Every employee must be aware of the policy. It's very important. It must be put before your new employees, but old employees or existing employees should also sign on to the policy. And it's helpful for the employer to have some sort of proof that becomes necessary later on that the employees are familiar with the policy. Ongoing training is extremely important, and it's particularly important given our socio-cultural dynamic. No complaint should be ignored. Every complaint that comes to the organization ought to be addressed. We can't call what is considered offensive behavior just a little joke. It doesn't work like that. If it is that the victim reasonably so finds the behavior to be offensive, then it ought to be addressed. It's important to remember that the procedure ought to be confidential, yes, but also fair and transparent. Both the victim and the alleged perpetrator have rights that ought to be protected until the allegation is proved. the alleged perpetrator has to be protected too. And so it is very important to be fair to the perpetrator as well as to the victim. And finally, because in industrial relations and within the workplace, what is important is to have a very sound employer relationship. Follow-up care for victims is extremely important. At the end of the process, victims really shouldn't be sort of left alone and, oh yes, the person has been dismissed or the person has been disciplined, so that is the end of the story. Often, when these situations happen, the effect can be quite long lasting. And so counseling for the victim is very important. As long as the entity can afford it, it really becomes very important in the context. That's my presentation, my half of it. Thank you so much for listening. I will now hand over to Emily.
Yes, thank you, Nicole. That was excellent. Emile, are you ready?
Yes, I'm ready. Thanks very much, Nicole. Yes, excellent as always. So I am going to pick up where Nicole left off. Now, one of the first things to understand about sexual harassment is potentially one of the most nuanced areas of labor law. What does that mean? Sexual harassment is in the eye of the beholder. Now, for those of you who may be old enough to have been fans of Friends, you might remember a character called Joey, and one of Joey's favorite lines was, "How you doing?" As versus, "Are you doing well? How are you doing?" But the intonation, the implication was, "Are you doing great? You're looking well," etc., etc. So potential sexual harassment, they're very clear-cut cases. So for example, the case that Nicole cited, it should be readily apparent to any individual that, the nature of touch in that Trinidad case, clear harassment and bordered in fact on sexual assault, which we'll get to later in the presentation. But there are many times when sexual harassment can actually be very nuanced. And it is not about how the the person who is kind of delivering the harassing act, what their intention is, but how it is received. The part of the difficulty, so if someone could close their mic, part of the difficulty is how culture in Jamaica interacts with the workplace. What does that mean? Culture in Jamaica, and depending on your upbringing and community and so on, you may have been raised in an environment where touch, for example, is very commonplace and is accepted, and even what some might consider sexual touch. That individual may then come into a workplace and interact with people who are raised in a different environment, and in fact may have different views as to what constitutes acceptable touch. One of the most difficult things to police for sexual harassment is, to bring across that understanding that even though for you, what you did was perfectly fine, it was not received as being perfectly fine. And so many people don't have the ability, emotional or otherwise, to put themselves in the place of someone else. And that really tends to be the difficulty, particularly if you look at things like the Me Too movement and that type of thing, you have individuals who engaged in systematic behavior, had been engaging in systematic behavior for an extended period of time, and perhaps no longer even felt that it was wrong. If you listen to some of the responses, it was par for the course for that era, for that time. It was standard behavior in their view. Or you have seen issues of people who are of different generations as to what constitutes acceptable behavior. Now, let me get into a bit of the meat of the matter. So, for our purposes and for the discussion today, we look at things like what is sexual harassment. So practically now, is it holding the hand of a fellow employee? So if I, take the hand of a coworker and say, it's all right. So holding the hand may be in the context of consolation, and it may be welcome in the context of consolation. But if it is an unasked for hand holding, then what then is that no harassment? Is it any form of touch? If I touch you on your shoulder to get your attention, is that harassment? So I've heard of complaints that, well, you touched me on my back, and that is where my bra strap was, or is rather, and so I take that as being a sexual touch, right? And so is it hugging? So some people, they may say, oh, I'm just a huggy friendly person. But then one hug might be seen to be sexual and another hug neutral. Or is it I like to call it the church hug, where you have minimal body contact and there's a pat on the back where you lean out, or is it a body facing hug? Which hug is harassment and which hug is not? As I said, is it the whole Joey Tribbiani type of speaking in a suggestive way? Because again, are you giving a compliment? Oh, that's a nice dress, Nicole, or Nicole, that's a nice dress. You know, again, you have that nuance, that intonation that affects how it is communicated. And so it then makes it very difficult for an employer to police sexual harassment in the workplace. And part of the difficulty that you will repeatedly have with it is many times there are no objective witnesses to the act, because most of the times the individual who engages in the potentially harassing behavior does not do it in front of everyone. If they do it in front of everyone, it's probably because they didn't think it was harassing behavior, right? Which again speaks to some other things I just mentioned. So this is exacerbated by the fact there's currently no definition for sexual harassment under Jamaican law. So we have proposed legislation, which has been proposed and retabled in Parliament, and we have discussed, and Jambar itself has actually made presentations in Parliament on a version of the legislation that is currently before the Joint Select Committee. But we're using that for now as a guide, and hopefully the definition at least remains in any legislation which is eventually passed. So under the proposed legislation, sexual harassment is defined as the making of any the making of any sexual advance towards a person by another person which is reasonably regarded as unwelcome, offensive, or humiliating by the person towards whom the sexual advance is made. Now, again, that is an essential element of it. It is not how you, and this is frequently the man, is not how you, the man, view it, but how it is received. And that it tends to be one of the greatest difficulties in training in sexual harassment policy, because you could have a lovely policy that has all these nice, things and the complaint procedures and so on. But really, what you want to do is prevent sexual harassment from taking place at all, because it's one of those issues that once you have to fix it, it then becomes a problem. Sometimes you may also need to be training your CEOs, and the heads of organizations and that type of thing, where as to what constitutes acceptable behavior and that type of thing. And so there are those nuances. But one of the important things is that it is how it is received, not the intention of the person who engaged in the act. So there's the alternate definition here, that it has the effect of interfering unreasonably with the work performance to whom the of the person to whom the sexual advance is made, or creating an intimidating, offensive, or hostile work environment. Now, there have anecdotally been cases where women, in a few instances, men have been pursued relentlessly. So they haven't stroked your calf, they haven't touched your bottom, they haven't actually done an overt physical sexual act, but they are constantly in pursuit, right? They're constantly inviting you out. They're constantly saying, let's have a drink. They're constantly saying, let's do this. Let's speak outside of work hours. In the current environment, they're sending you WhatsApps. You don't have any nice pictures you can send me, you know. And so you can have harassment that actually doesn't involve the other person touching the other person at all. And it doesn't, in fact, involve someone actually saying something sexual, right? So there's usually this concept of, well, it needs to be sexual in order to qualify as being harassment and so on, or particularly sexual harassment. But if one applies the definition that is proposed in the legislation, if you engage in behavior that creates an intimidating, offensive, or hostile work environment, that can constitute harassment. Now, so we move to the next step. So you have observed behavior as a manager, because most people here presumably are managers, whether HR managers, supervisors, and so on. And you are now in the workplace and you said, okay, I've gone to the sexual harassment seminar. Emil and Nicole presented well, they've trained me well, and I now know how to identify it and attack it. So you observe something in the workplace and you say, aha, there's sexual harassment right there. But many times you need context. As I had said before, you may have a situation where, again, it is received in a reasonable way based on the circumstance or the nuance. And I'm not talking about obvious situations where somebody's hand is where it should clearly not be, right? I'm speaking about, again, the more nuanced interaction where you're giving a pat on the back, or you're saying okay, or whatever it may be, that could be more nuanced. And then it's always interesting, when you have this talk about culture and workplace culture, because some places will or tend to have a different type of interaction amongst employees than other places, and in terms of what constitutes acceptable interaction. So you have this whole challenge between tension between objective and subjective. So again, you want to get the context. The concept is not to embarrass anyone and make it perhaps more than it needs to be, depending on the circumstances. So you speak to each employee away from the other so that they can give their unbiased and uninfluenced version of events. So let's say, for example, you have a boss and a secretary, you're in HR and you say, hey, what's happening here, when they seem to be very physically close. The secretary in the presence of the boss might say, oh, that's fine, no worries, and so on. But on her own, she might say, well, I actually was uncomfortable with how, Mr. Brown, interface with me. So again, it's important to have an individual discussion if you are investigating something you've observed. The And of course, the most important thing is if you are not yourself HR, you report the matter to the Human Resources Department. Now, one of the things we know is that method has been um, emphasized significantly by the IDT. Procedure, process, fairness, right? So while may want to be efficient and say, okay, you horrible human being, get out of the place, right? You don't want to run into a situation where you can be said to be sanctioning somebody without due process. So you want to report it to the Human Resources Department, um, and so they can then address it and apply the process, right? So you want to ensure that due process is always followed. Now, again, looking at the interaction between staff, you have questions like what constitutes an acceptable method of communication, right? What is an acceptable level of physical interaction? Compliments, are they now illegal? Can I say to Camille, that's a nice suit, right? Or is it that I can say, well, no, I can't say that. Any thought that I have, positively or otherwise, about Camille, I have to keep it to myself because then I may be accused of harassment, you know. But what you don't want to do, wherever your particular company lands, you don't want to be inconsistent, right? You need to be consistent in your application of the policy. So what's good for the goose is good for the gander as well, because there is a culture in our society, for example, that says, well, a woman can say to a man, don't tell me about my outfit, but a woman can say anything she feels like to a man and say, boy, those pants fit you well, man. Oh, I like how, thing, and oh, it just look good at, because men should receive that positively from any woman who says anything positive to them about their bodies, and that should not be negative received anyway. What, you don't like woman, and so again, this is how our culture interfaces with the law, you know, and so you do have that context that you sometimes have to overcome. Now, again, there's no one answer to any of these questions. But what there needs to be is a decision as to where you fall in your company in response to these questions. You have to kind of think about it, and sometimes you have to give examples. And this is why Nicole, for example, had spoken about training and the need for continuous training, because I said almost more important than the policy is the training, is to have the individuals at all levels within the organization understand what constitutes acceptable behavior and what constitutes unacceptable behavior, right? So one of the things that's clear, so you can be friendly. So, there's nothing that says, well, you can't be friendly, but without sexual innuendo. No, I always like these examples, which are sometimes funny, where they said, I didn't like the way he looked at me, you know. No, some people have been said to have bedroom eyes, no matter how they look at you, regardless of their intent, they just always seem to be looking at you in a particular way, you know. And also, you may have people who are particularly sensitive due to experiences that they have had and life experiences that they have had. It may get to a point where you have some cultures where it says, "May I touch you? May I shake your hand? Can I shake your hand?" Where they don't assume and go. They're not Trump, where they're not grabbing and pulling in people just randomly, and the assumption that everybody thinks it's okay. Some might not. Now, again, sometimes in your interaction with a fellow employee over time, you can get an idea of what they are comfortable with, again, within objective reason. Even if they're comfortable with you resting your hand on their rear end, that is not appropriate in a workplace environment. So even if they have, so again, there are degrees and extent within which comfort can influence policy, right? So they are clear, and they need to be very clearly demarked um, limitations on comfort, but there should also be some level of flexibility. No, so we sometimes will have issues like this. What if the other person flirts with me, or I thought they were flirting with me? So I'm flirting back, you know? So again, forgive me for using Camille as an example again. Camille tells me that's a nice suit. I say, oh, that's a nice outfit. And I say, oh, and I like your hair. Oh, and then, oh, and shoes. Oh, they go so well. And you start along a particular conversational track that may then perhaps at least on one end go farther than one anticipated, right? So, you also have the people who again give them an inch and they take a mile, right? So you do need to have some level of acceptable standards and examples of acceptable communication, all right, in the context of setting policy. Because remember, policy, a lawyer can give you what I call boilerplate policy. But in something like harassment, it is important that you examine that policy again in the context of the operations and functionality of your company, and you train in the context of your company. So what is the effect when it is that there is a breach? So we can see there's a potential for the company to be sued. Let's say, for example, some bright person decides to bring it as, a breach of a safe system of work. You have brought me in this place, and this is what I was subject to. Of course, whether or not it constitutes an actionable claim, again, degree and extent, knowledge, and those things which will arise, right? Disciplinary action may be taken by the company against the employee. So that's clear. When there is a report of a breach of the policy, then you can proceed. You can have issues like reputational damage. If it is that something is reported in the media, in the press, about a particular complaint at a particular company, and then you might hear, oh, is that how that company operates? Because that company could have 1,000 employees and you have one individual who is acting in a particular way. And then, it's very easy for people to say, well, that's how the company is. So that is also something that you always have to be aware of, right? Now, some of the things that, again, you need to be aware of when a complaint is made is what constitutes criminal conduct that needs to be reported to the police, as versus what is conduct that you deal with internally from an employment standpoint. So we have sexual assault is a criminal offense, clearly. So you can be arrested and charged, and if convicted, may be sentenced to prison. The sentence for grievous sexual assault can be up to life imprisonment. So examples of sexual assault involves unwanted touching. So just a mere act of unwanted touching in and of itself can constitute sexual assault. Now, unwanted touching is an example of something that overlaps both. So it can be both sexual harassment and sexual assault, right? But again, degree and extent as to whether or not it is likely to be acted on by the police. So if somebody touched your fingers and you made a complaint to the police, it's quite unlikely that they would frankly do much about it. Clearly, you have clear things like forced sexual acts, oral, penetrative contact. That should be very straightforward. That in an unwanted context, all of those things are clear criminal offenses and no longer fall within the purview of company administration, right? So a claim based on sexual harassment made by a fellow employee is usually in the form of a complaint, which may result in disciplinary action being taken. Now, as Nicole had adverted to, unlike most offenses in the context of a company, it's not just a question of disciplinary action or not. Sometimes there may also be counseling because you, depending on the nature and extent of the harassment, it may not justify termination. Now, remember, the case Nicole had cited, again, based on the facts and circumstances of that case, I think it would be clear to anyone that the termination was justified based on that conduct. But sexual harassment is one of those areas that it's like insubordination and gross insubordination. Depending on the nature, degree, and extent, it may not be sufficiently egregious to justify termination. What does that mean? So you may have an incident of harassment where the so-called perpetrator remains in the company and continues to work with the victim, right? In that context, what you may wish to do is engage in counseling for both, right? Both separately, and perhaps a form of mediation whereby you can have a open conversation, because again, you may have instances where the individual may not realize that what they are doing, the behavior and conduct of their behavior, is such that it constitutes sexual harassment. They may well be thinking, I am just being friendly, I am just being nice, I am just, right? Without either being willing to or able to recognize that that behavior, while acceptable to some, is not acceptable to all, and is certainly not acceptable in a workplace environment. So a distinction always has to be drawn between how you act, as I'd say, out on the road amongst your friends and so on, and how you act and conduct yourself in a workplace environment, right? So steps about how to prevent harassment, because really that is the primary purpose, in my view, of a policy and training, is prevention, right? Not so if it is that the situation has arisen, right? It then becomes and potentially has the potential to become an issue in the workplace, right? That can affect productivity and etc. Right? So some of the best ways to kind of address these things from the get-go is to have a clear communication policy as to any concerns that the staff may have. And again, sometimes if the act of harassment involves someone very high up in the company, you may need to have a system in place where that person can go outside the chain of command. And perhaps if you have a company with a board, then it may be a subcommittee of the board that may then deal with harassment complaints, so that the harassment concerns can encompass everybody who works in the building, right? Because again, experience has shown that harassment tends to be a top-down issue, right? So again, you just have to reiterate these things for the employees, understand the significance and that it constitutes a breach. Now, I perhaps don't have enough time to get into the whole context of consensual situations.
We
No.
don't have one, no antibiotics. Yeah, well,
If you could have mute right there, yeah.
Yeah, I think it would be good if you got into the consensual a little bit, Emil. Take a few minutes and do that. Yeah.
So there is this concept again in a workplace environment when one looks at consensual relationships. They say, oh, well, you know, it's fine. Everyone has agreed. We know what we're doing. We're grown people and so on. But then many times what happens is that one wishes to end it before the other, or you can have a situation where the relationship is one where it involves someone who can affect the work relationship, promotion, salary, and so on of the other. So some companies have a policy against power imbalance relationships, right? Because you can have a circumstance where somebody can agree to that interaction, that relationship. But if you really dug a little deeper, you realize that they only kind of agreed to it because they thought that, if they didn't, it would create a negative workspace, even though that wasn't said, right? So while it is that there's an element of we're two grown people, there is also, from a work environment, job perspective, that one generally wishes to discourage that type of situation, particularly where there is a power imbalance between the parties to that interaction, right? Because is your consent truly consent where it is your boss who is either you report to directly or maybe it's 2, 3 levels above you has proposed an inappropriate interaction, right? Now, one could argue, and it frequently would be argued, well, she agreed. So what's the problem, right? So again, you may have to look at that as not necessarily a harassment, because underpinning harassment is this context of unwanted advance, right? So one might say, well, if she agreed, it can't constitute an unwanted advance, and therefore there's nothing to pursue from a disciplinary standpoint. But again, you can look at this context of power imbalance relationships as to whether or not you wish to extend your policies to go beyond just what I call harassment simpliciter, and you are addressing, I said, a power imbalance situation. Right. So these are your takeaways from today. I know sometimes it can be difficult to focus, to listen, and process everything that is presented. But so here we say communicate with the staff, lead by example, because another thing again is that the managers in the organization set the tone for the organization, right? So, Camille is my favorite example today. So if Camille comes to work in sleeveless tops and jeans and sandals, then her staff members will be like, great, that's a new workplace policy, and so she would then set the tone for her office space, for her environment, and then others would say, okay, this is how this works, because people look to the head of the company or the head of the department, the head of the thing, to determine how they should behave. Because again, so you may then create an environment where you might not be the perpetrator, but then the person below you might say, well, Emil can do that, so why can't I do that? And again, you get into that type of issue. And I have to the guy outside. Right. And then take initiative when you are confronted with questionable situations. Now, I'm putting up this picture. I'm going to ask you to post in the chat, right? As to whether or not you think, based on this picture, there is harassment taking place. Just at the picture, you're just looking at the picture, and you're going to post in the chat as to whether you think anyone and in this picture is being harassed and why. So Camille, you want to maybe give them 2 minutes, 5 minutes to do that? And then we can take some of the responses in the chat to see.
Okay, yes, because as we look at the picture, is she pulling back because he's being aggressive? Or is she leaning back because she's comfortable? Let's see what our chat is saying. No, the conversation seems to be welcoming. That's Teresa.
Okay.
L. Simpson says no. And some, let's see here, they're coming in fast and furious. I think she's comfortable.
Uh-huh.
No, her body language seems relaxed. She's comfortable.
Mm-hmm.
No harassment taking place. Both appear at ease with each other.
Mm-hmm.
That's Garthia. Cherie says no. Tanya says no. Overall, people are saying no, Emil, that there's no harassment.
All right. And you know, what is interesting with this, right? Because these are things like, these are some of the elements you look at. Body language, facial expression, distance between speakers. Now, if you show this picture in North America, I'm sure they'll say, oh, he's trying to dominate her.
Well, Rachel says his pelvis is pushing forward.
Elvis is pushing forward, right?
And then there is someone else who says it appears a bit aggressive.
Uh-huh.
I suppose it's his hand, and this is Alicia.
Right. Uh-huh.
But then Charmaine says would expect her to be positioned differently if she was uncomfortable.
Right.
Yeah.
So, you know, as I said, it's interesting in depending on the audience, the type of responses you receive.
And
even
Trevine says, hard to say. Yes.
So the answer to this is it's a definite maybe, right? So what you, again, this is a situation where you have to get context, right? Because it's an interesting exercise, but we know that you can't just stay from afar and look and tell. You know, this may be how this individual likes to relax, or it may well be that she's leaning out away from him and doesn't want him to get too close, right? But you would have to speak to her to understand that. I don't think anybody thinks that he's being harassed. Does anyone think he's being harassed?
No, nobody has suggested he's being
The poor man, the poor man. Suppose, you know, he's like, oh, you know, I don't know what she's gonna say about me. But again, yes, this picture does suggest that the man is more relaxed and may well be in a greater position or location to be, you know, kind of over the woman. But again, that may be a height issue to a degree, but she's also, again, leaning away. But these types of things shows you, you know, if he was a little closer to her, would that constitute harassment? Well, we know in COVID that anything under 6 feet is a no-no, you know. So I need to measure, and you have to walk with your ruler and say 6 feet, 6 feet. But as a general rule, you look at issues like this and it's like, well, what is harassment? Is this harassment? Um, but yep, there ended my contribution to the presentation. So back to you, Camille.
Thank you so much for that, Emil. And no, none of your remarks were taken badly. They were all quite welcome, including the shoes.
Thank you, Camille. It's good to know I've been exonerated.
Definitely.
By an objective panel.
Members, what was good about both our presenters was how practical their guidance and presentations were. And they both spoke about policy. And Emil summed up so nicely when he spoke about communicating with the staff, leading by example. And Emil, I appreciated your going into the consensual situations, because the question arises, so how does one get a date now, you know, in these new times, versus that young woman who wants a job? And in Jamaica, we have very often heard references to the casting coach. So she agrees because she's the first one graduating from university and she needs in her family, and she needs this job. There are so many nuances, but I really want to thank you, Emile, for the learning as well as the practical guidance that you have provided this morning. Members, we are going to take questions via the chat. Yes, the presentation will be available following the webinar that has been asked by many persons. And before we start on the questions, I just want to reinforce the fact that there needs to be a policy which makes it clear what the organization's position is. And as Emile pointed out, that policy, yes, you can have a boilerplate document that you get from the Bureau of Gender Affairs, I think has one, but you have to know, craft that policy for your organization and what is suitable for your organization and the culture within your organization. And once that policy has to come from the top. The board has to say that we do not tolerate sexual harassment in this organization. So it's clear that if you want to behave like that, you go and you behave like that elsewhere. That policy, as both Nicole and Emile pointed out, the persons who are administering it, the supervisors, they have to be trained. HR has to be trained. Not like an organization I know where when it was reported to them, they kind of laughed and said, oh, yes, the common thing is that he manages with his fly down. Clearly, those days are gone. It was a few years ago. But we have to ensure that everybody in the organization understands that we don't tolerate this here. And then we train and we train so that persons can understand that if this happens, this is who I report it to. And as was pointed out, very often there are subcommittees of the board. And I have seen where it is the audit committee that the report can be made to, similar to reports made under the whistleblowing policy. Some people twin them. So the report is sent to a particular website and it falls under the auspices of a board committee, which again shows that from the very top, we are not supporting this kind of behavior. Let us go to the chats because I think we have a number of questions. Lisa C, given that we're now in the technological age, what are the considerations regarding harassment that may take an electronic form between colleagues? Boy, Lisa, we can't even deal with the ones before electronic and you taking us into electronic. All right, Nicole, would you like to tackle that?
Sure. I think in any assessment, we go back to the definition. I read a case recently, it was a Canadian case, in fact, where the perpetrator was a male, victim was a woman, and what he was doing was anonymously sending pornography to this woman. And it a part of the case was, but this woman sometimes sends these kinds of messages to the men as well. So what do you do with it? But in her situation, she didn't know who was sending it because it was anonymous. He would sometimes say, you know, hi, I miss you, I love you, good to see you again, and that sort of thing. And he was eventually dismissed. And what they had to do, because it was anonymous, they actually had to bring in, I think it might have been external IT. This was out of Canada, as I said, and trace the emails back to the computer, the gentleman's computer. And that is how they realized that it came from within the organization, because, you know, they didn't know because he used another name to send it. So the considerations, I would say, at the core are similar in terms of a tribunal making an assessment. Is it offensive? Does it disrupt the workplace once it's identified? Is it humiliating? there is the concept of reasonableness. What would a reasonable person say? How would a reasonable person, and I say reasonable person because there is a debate about whether it ought to be a reasonable person or a reasonable woman, because Emil spent some time looking at the fact that men and women culturally view matters differently. So those considerations would be the same. Even whether or not it is the technology is involved, I think as well, they for firms and organizations sort of, it's difficult because I think to myself, what would a small firm do in the situation that I mentioned? How would they be able to have the technology to be able to do that tracing to determine whether this was a cyber issue and that sort of thing? So I think that those kinds of things are real, but at the core, there are similar considerations,
Yes,
and it's unacceptable.
yes, Nicole. And I think the behavior mentioned too may also be a breach or be a cyber crime.
Yes, 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 yes,
So,
yes.
so there would perhaps be two angles from which you could tackle this. And I'm glad you mentioned this small firm, because I had a situation where there were three people in the firm: the owner, the receptionist, and the driver. And the driver proceeded to sexually harass the receptionist. So don't think that because you are a small firm that you are going to avoid this situation. You still need to have your policies. And of course, things got very interesting when the receptionist's boyfriend decided he needed to also get involved in solving the problem. So it is a real issue that we as business people have to tackle. Simone is asking us, is any physical touch assault? And Emil, I think you dealt with that, but you want to just touch on it again?
Well, the important thing again is unwanted, right? So if I shake your hand, that is not an assault and is not harassment, generally speaking, right? If you have an objective standard in a workplace environment to say, okay, in this environment, we shake hands, we do not hug, for example, and you breach that, then you have a problem. But it is not, again, it's a cultural element, but once it is any unwanted touch, like for example, you know that if your doctor examines you without your consent, that's an assault, right? That's why you have to consent to going to your GP. When you go to your GP, there's an implied consent when you take off your clothes and lay down on the bed, right? For it to be examined and that type of thing. In any environment, no one has a right to touch anyone else. There's no right to touch, right? So you would need to ensure that this is written clear and concise in terms of level of interaction.
Okay. I'm seeing lots of comments saying great presentation, which we are all endorsing. Thank you both. Let us move on now. And this is from Olivia. What if a coworker says something lewd or gestures inappropriately to another coworker who consents, but an independent coworker overhears or sees it and is offended by that second-hand sexual harassment? It's the first time I'm hearing that term, second-hand sexual harassment. Who wants to tackle that?
Um, well, I can speak briefly on that. Actually is addressed in the legislation. Yeah, again, if it's ever passed, regarding creating an environment. So it's not necessarily directed at you, but let's say two men are always talking about that woman and how she stay and that one over there and so on, and there's a woman there who feels uncomfortable. That actually can constitute a form of harassment. So even if two workers are um, agreeing to converse in a certain way, they cannot converse or should not converse that way in an office space, right? So even if the two of you are having a conversation that you agree with. And but again, this is where policy, a clearly written policy comes in. So if you have a policy that mirrors the draft legislation, then it would cover something like that. But many people, their policies may not cover something like that. And so when someone makes a complaint, then well, it's not really here, so you can't really do much about it other than have a conversation with them and say, okay, I would prefer if you not speak like that in a workplace environment.
Right. Yes. Yes. And Emil, because the something I had as a question is, if you have no policy, what would be the basis of the disciplinary action, which is what I think you were just alluding to there? If there's nothing that says that this behavior is wrong, how do you discipline that employee?
The simple answer is you can't. Um,
Precisely.
you can't. So there's no inherent power unless it is you try to bring it under some other general rubric, and we who represent employers have had to be elastic at times in trying to fit things on existing things where, so, but generally speaking, the answer is no, you can't take any steps to discipline someone if it is not a breach. Because to be fair to the alleged perpetrator, I need to know that it's a breach. So I know not to do it, if you understand what I'm saying. So, you can't really rely on people's instincts necessarily. Again, and I touched on that earlier, to know what is right or what is wrong in this workplace. Because it may have been right where they worked before, but wrong when they come to work here.
So true. And that again reinforces the point you have both made, that there is need for a clear policy, a policy that says if you behave in this particular way, then you will be subject to dismissal. Or you as an employer may find yourself in a situation where you want to do something and your hands are somewhat tied. So, a clear policy and training, I have found that it is very useful before the board finalizes the approval of the policy, or senior management, that you actually take it to the staff, you discuss it with them, and those discussions can be hilarious because you will have gentlemen putting forward their positions and ladies saying, no, this is how we feel about it. And those are some very interesting conversations. And then of course you hear about the cougars, and we get into other, and often too, you have found that men say, yes, we want this policy because we want it to be clear. Nicole, did you have anything to add on this point?
Well, I'd say two things. One, when we talk about a policy, some organizations already have disciplinary policies. And so you don't necessarily have to, certainly as a stopgap, you don't necessarily have to have a completely new 20-page document called the company's sexual harassment policy. It can be incorporated in in your existing policy, and that too can be helpful. But as I said, I mean, I did go through, it should include the definitions, and Emil went through. That is ideal, but it is also helpful to start somewhere. Believe me, it is better than not having anything, because you leave yourselves too open. The other thing that I mentioned, based on the last thing that you said, is, and Emil mentioned this, remember that sexual harassment is gender neutral. The truth is that women are disproportionately the victims,
Yeah.
but remember that a woman can be the victim from another woman. So a woman can sexually harass another woman. A man can sexually harass another man. A woman can sexually harass a man. So when we're looking at the issue and talking about the issue, please remember the gamut of it, and that it is that all of the employees within the organization are susceptible to this. So I would just say, let us bear that in mind too.
Thank you. Thank you. Tashina is posing quite a question here. My question is aimed towards sexual discrimination against women in the workplace due to refusal of sexual advances. Is it considered harassment, discrimination if a female in a higher position opposes another female staff member in the workplace due to sexual advances. So Nicole, that was kind of what you were getting at. This is
Hello.
female on female. Hi, Karen. Would you like to go on mute? Yes, Nicole. You want to tackle that one and then we kick it over to Emile?
Sure. I'm just a little bit unclear. I mean, if it is that the person is asking about a female in a higher position sexually harassing a female in a lower position, then that is really classic sexual harassment. And in fact, Carla's book, there's a case on it. I think it's Wood and Freeloader, where there was some undue sexual sort of infringement on another female employee. And that was in the context of the breach of mutual trust and confidence. So that is sort of clearly accepted as a breach. I'm not sure though if what the person is asking is whether it is that the female knows that an advance is being rejected, meaning someone else is making the advance, and so there's a sort of same gender hostility that is. I'm not
Yes,
sure
Tashina, do you want to weigh in? Do you want to unmute and explain exactly what you're asking so we can ensure we're answering? No, Tashina? Okay, if at any point you want to give us further.
Well,
Well,
I think this
Michael,
Camille, I would think so, yeah.
well, all right. I think my interpretation of the question is, if someone is not promoted due to refusal of an advance, whoever does it, let's say female, female, male, female, whatever dispensation it takes, can that amount to harassment? No. Again, the draft legislation, I think, addresses this about proposing, an employment benefit in exchange for sexual favors. Now, again, it may not be so explicit, but you then know that when you refuse it, again, that goes to the whole power imbalance type of situation. Now, there's no law against that right now. And it is also something that is very difficult to police because the supervisor may well create on paper reasons why they're not advancing an employee. They don't do good work, which is very difficult for a third party to perhaps assess, or they don't do that. And then there's also the concept where you do have what I call false victims who actually are bad workers and try and give excuses for why they are bad workers. So you have both. You have the actual victims and you have what I call false victims. But it is very difficult to police that. But the only way you can get around something like that is to have an objective performance assessment process whereby people are advanced based on objective criteria determined by more than one person. So let's say, for example, if the company is large enough, you can have the person supervised by their immediate supervisor and their head of department. So when you both sit in a meeting, at least it hopefully will bring some objectivity. I'll be frank, you're not going to cure every possible issue that can arise. You can't. You never will be able to, but you just try and have it as close as possible to an objective environment and scenario.
Yes, and thank you for that, Emile. And as Nicole said, we have to start somewhere. Because, I mean, I had a client come in here and show me the WhatsApps where her person in HR was offering to lick chocolate off her body. So in Jamaica, we are far gone. So anywhere we start, we will be stepping forward. And the fact is that this does not represent our organizations. So as business people, we don't have to wait for the law to be passed. We know what is right. We know what is wrong. So we need to leave here today, everybody who doesn't have a policy, and put a policy in place. And it's not going to be perfect from day one. And I don't know if we'll ever get to perfection, but at least we will start and there will be some protections for people. There was a question about gestures. I think you dealt with that, Emile. I don't know if you want to speak a little bit more about gestures because those are defined in the bill. I think they mentioned that.
Well, again, gestures is the area of subjectivity, where depending on the nature of the gesture, it may be open to interpretation, right? So again, context of the gesture is important. So it is that's the type of area again where sometimes you would have to have a conversation, do a form of investigation, not with two police officers in the room, but just have an individual conversation with the individuals involved, with the complainant, and it may result in what I call just counseling. It may well be that the solution to that scenario is to speak to one or both individuals to say, well, I understand you're fine with this, but this is how it was received and how, this is not taken in the way that you intended. And so it would be better if you desisted or behaved in a different way, and that type of thing. So many of these issues are really not, it's not ideal for the disciplinary hearing type of structure with your panel of three and someone leading evidence and that type of thing. Many of these infractions, once they're not too egregious, even in the courts, we're looking at alternate dispute resolution, right?
Mhm.
So in a workplace environment where arguably you both are continuing to remain in the workplace, conversation really should be a starting point, and sensitization. And then you kind of escalate from there if there's no change in behavior.
Definitely. Because usually what the victim wants is just for it to stop. So he or she can get on with doing their work and making progress in the organization and doing what they were employed to do rather than being hindered. Yolande asked, how do we deal with cyber sexual harassment in the workplace? But I think we dealt with that. And then Mitzi is leaning into the point that Nicole just made. If there is no policy but a disciplinary code that includes harassment. And what I heard from Nicole, Mitzi, is that that is a good place to start. Nicole, you want to say anything further on that?
It's a good place to start, but I don't really think that it's not that difficult to add to that. We are taking a zero tolerance position on this matter. It's really not that difficult.
It's not
But if
hard.
it is, no, it's not. Come on, it's not that hard. I mean, your board is not going to reject that. They won't, not in 2021. So if it is that you have started there and you've included harassment, then the first thing I would say is, what is your definition? Now that you've had this presentation, look back, expand the definition perhaps, put in a statement that include a statement of zero tolerance, include a statement that they're entitled to be free from harassment and so on. I don't think that those things are very difficult. So I would love for that question to be rephrased. What was it, Mitzi? I'd love for that question to be rephrased to say, how can we move beyond the code that may not be so inadequate, that may not be so adequate at the moment? And really, you do have some low-hanging fruit. There are some things that you can put in there next month when they have the next board meeting. You put it to them, have them sign off on it. It's not that hard.
So
Sorry to be
right.
rough on you, Mitzi.
No, 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 we're not. We are saying to Mitzi, yes, we want this, but we want even more. And to Emile's point, the board is responsible for setting the tone at the top. And if there are any board members here today, you should definitely be going to your next board meeting and inquiring what is it's the anti-harassment policy in this organization, right? Because it is a principal board responsibility, setting tone at the top. And certainly nobody in Jamaica right now can avoid the constant issues we're having with gender-based violence. And we know this is just one slim aspect of it. This relates to the workplace, but everything we do goes towards improving the situation in which we find ourselves. And to that point, Erica is asking, do you know of a timeline for the passing of the long-awaited legislation? Can the internal policy have legislative teeth without the establishment of a government policy? Of course, the internal policy has teeth. Just in the same way you say that if you do this in my organization, I will dismiss you. You can say if you sexually harass somebody and you have been warned and you do it again, I can fire your tail. Emil, are you going to tell us that we can't do that from a disciplinary point of view?
I agree with you as always, Camille. Let me address two things. One, the legislation is at the, what I call Joint Select Committee. That means they're reviewing it, listening to stakeholders, getting input from everybody who may be affected in order to settle, text. Once the text is settled and then it's updated, it will be retabled, meaning that it will be put back before House of Representatives and the Senate and so on. And then once they pass it, and then it's given assent by the Governor General, it becomes law. When will that happen? Only Jesus and God alone knows. Allah, anyone knows regarding the timeline for that. But as Camille rightly said, this is the only point of distinction between having a sexual harassment policy and a sexual harassment law. The sexual harassment policy creates a framework by which companies can be sanctioned for not having a sexual harassment policy, right? By which institutions can be sanctioned for not having a sexual harassment policy. It sets up things like a sexual harassment tribunal to specifically address complaints arising from sexual harassment, right? So what it does is really set up a different kind of avenue, an additional, or create a positive obligation for companies to put, and institutions, schools, and so on, to institute policies. However, the fact that it's not illegal doesn't prevent you from having your own policy and taking on your own initiative to put in place a policy. And certainly, if you have a policy in place, an employee breaches that policy and they are terminated as a consequence, they take it to the ministry, IDT, you can hold, assuming you have a good representation,
Like Emil or Nicole.
quite, you can then defend your company's position in doing so.
Definitely, definitely. Outside of an employee handbook, do you recommend having a standalone policy for the employees to sign? And I think you touched on that a little, Nicole, but you want to just quickly answer that one specifically?
Yeah, I mean, the short answer is yes. And Emil just said it as well. The detail is always more helpful because what it does is that it gives you more latitude when disciplining the employee. It provides an understanding of what the offenses are. And what it does is it brings sort of clarity to the workplace. Because remember, at the end of the day, there's a principle underlying this. You want a good work atmosphere.
Mm-hmm.
And in order to get to that point, people need to know what they can do, what they can't do. If a particular action is taken against me, what can I do in response? Who should I go to? When you go to that person needs to know what they should do and who they should go to. So that's what the policy does and outlines. So it is desirable and perhaps most desirable to have a standalone and detailed policy. If you don't, though, as I said earlier, and as Camille said, you've started, you do need to start somewhere. Start somewhere and work your way towards that.
Definitely. Should there be a timeline in which reports of sexual harassment are to be made to human resources? That's coming from Simone. Who wants to tackle that one?
What I can say is that there there's a general principle in employment law that complaints should be dealt with expeditiously. To be fair to the complainant and to be fair to the perpetrator or alleged perpetrator, right? Because you have issues, particularly in something like harassment of recollection. If you are saying, and I think Minister Chuck infamously made some of the references to like this, that I had a conversation 10 years ago in which I harassed you. I may have. I literally don't know. I can't recall. And it makes it difficult to adjudicate. And so, fairly. And so, particularly with something as nuanced as harassment, you need to have a policy which sets clear timelines for complaints because it is unfair to someone to say, well, in a conversation I had in your office 2 years ago, I think that you acted in a way that was inappropriate. And, Nicole, and well, Chair was busy, Lloyd. Sometimes we can't remember what you said and did last week, you know. And so, again, it is for everybody to be on an objective page where they can say, yes, in this meeting on such and such a date, I sat across the table from Nicole. I was 6 feet away from her. I waved, I passed the papers down the table, and I can clearly state I at no time touched Nicole or spoke to her in a suggestive manner, except that time when I blinked a little longer than I had something in my eye, again, as versus, I think I had a meeting, we talked about something, and, again, you have to be fair to both sides, and it has to be in a scenario where you can properly recall what took place and be able to document it.
Yes, yes, I agree with that. And I mean, if those who have lived as long as I have, now with all of this law and everything, when I think back at all the cat calls and the whistles and the this and the that and the comments, then I know now, I didn't know before, but I was clearly sexually harassed. But I really have no, what was always good was I was never in a position where I couldn't say no. And that is what worries me about this sexual harassment that we see facing us. So many of our women are in positions and men where they can't say no. So if we can focus on at this point in time, what happened maybe last year into this year and at least get sorted with no, I am happy for the going forward. We see here, so the timeline, I agree. I do agree. And I think, Nicole, I don't know how you feel about it, that the reports should be made within a reasonable timeline. And what I have seen done, which I think is useful, or rather I'm suggesting be done, is that organizations, especially larger organizations who have their policies, they do surveys of the people in their policy that says, if you are sexually harassed, one, do you know what it means? And if this happens to you, do you know what to do? To ensure that where you are today, everybody there knows and understands that the organization does not tolerate this. And if this happens, this is what I am to do. Because you are not going out there and employing anybody to come in and sexually harass people. Is there somebody wanting to make a comment? We would love to hear you. O'Shea? Okay. All right. All right. But must disciplinary codes have a bag clause, quotes, because it is impossible to describe all possible offenses? Who wants to take that?
All right. I presume by back clause, I mean that, the company reserves the right to take steps in relation to anything not specifically stated. No, which is a catch-all type of phrase that's normally at the end of a table or disciplinary code in some way. That's helpful, and that it is something that can be utilized again in a stretch. But then you end up in scenarios where the employee representative says that's unfair to the employee, to stretch it too far. Sometimes it can be so stretched that the rubber band breaks, because when you want to get into very, nuanced types of issues, it's difficult to rely on a catch-all like that. Um, that catch-all is most useful in things like the employee pulls a gun on another employee and points it to their temple. You may not have a clause, something in your code to say, don't point a firearm at another employee, but it should be obvious to anyone that that constitutes an offense that can be actionable and terminable. So it's kind of, so you rely on clauses for what I call things that like that, for things that are obvious and apparent. Those clauses are not so good, are not so suitable for more nuanced types of infractions where it's not readily apparent that to, what I call the average worker, that this is an offense.
Mhm. Okay. Denise, weighing into what we just discussed, is there a statute of limitation regarding reporting the offense? Does the legislation have any time period that you're aware of?
Because I think there
No,
was discussed, it was discussed, that hence as I said, Mr. Chuck's infamous statement
Right.
was around the limitation period and what the limitation period should be, for reporting. Certainly, like for unjustifiable dismissal, it's 1 year under the existing labor, legislation. I can't recall offhand where they landed with the limitation period for, under the draft legislation. But again, your policy, you can set your own timelines. You're not limited by that for how you deal with things internally. So anything in the legislation would be about complaints being made to the relevant ministry or the relevant that about it. So that's external to the company. You understand what I'm saying? It's not an internal complaint limitation, but an external complaint limitation.
Right, right. And Basil is here. He's afraid to compliment Nicole on her appearance as she doesn't know how it will be received. I'm sure, Basil, that Nicole will thank you for that.
yes, thank you, Basil.
And as I'm thinking through, I can remember myself whistling at a guy as well. I can't whistle, but I tried because, I was liking his suit. And there was Emil just yesterday or day before interrogating you about your three-piece suit. Can you imagine?
Quite,
We're going
quite,
to have to work out how this all unfolds.
quite.
But the
I kept the trauma inside.
so the fact is, it doesn't, because we know who we are as Jamaicans, and we have to do something that is culturally sensitive. But I think all of us know the real issues we're trying to get at. So don't let the fact that there are these nuances and difficulties stop us dealing with the real issues that we have to deal with here, like people not being able to progress because of some ne'er-do-well supervisor who is trying to take advantage. We didn't employ that supervisor to do that. And somebody's saying it is best practice. Is it best practice to declare relationships to HR? Who would like to try that one?
Well, so let's see now. Does declaration cure it? Usually when you have a policy about workplace relationships, the end result of a declaration is that you move them into different spaces,
Mhm.
so that that person can no longer influence, the other person's work, whether positively or negatively. Because remember, there's also the flip side to the workplace relationship, consensual, where you have two supervisees. One is in a relationship with the supervisor, one is not. The one that's in the relationship gets skyrocketed through the company due to the great work that they are doing with the supervisor, while the one who is not is like, boy, you need to pull up your socks. We can't tolerate that 5 minutes late that you've been coming to work. So that person is victimized by virtue of not being in the sexual relationship. So the usually the whole purpose of declaration is actually to move them into a different space so that if they are going to, become engaged and get married, and there are people who have met at work and gotten married and had
Many?
many legitimate relationships. I'm not saying a workplace relationship is inherently illegitimate, but it should not exist or take place in an environment where one person is supervising another or has control over the others, either advancement or whatever type of thing. So if you want to find your future love two departments over. You know, try to not have them stay within your. And some firms, for example, will have policies against a husband and wife being partners within that partnership.
Mm-hmm.
Simply because there are concerns of objectivity. Because your wife can tell you about that at home depending on how you voted. And vice versa, and vice versa. So it is something that again, you have to address it in a situation specific way. Because they may well not be a victim, it may be a positive relationship, but you just want to keep them in away from where anyone else will feel victimized by virtue of them being in a relationship, or that person, you're unclear whether or not that relationship was really entered into with objective consent.
Mm-hmm. Okay, great. Tashina waiting to say that her mic wasn't working, but she was clarifying to say that the advance was refused and the work environment is tense, and as a result, the person would have been passed over for a promotion. So
I
that
think
was what,
Emil dealt with that. Yeah.
yeah. Okay. All right. Now, Marcia, because we know we're coming down to the wire, so let's get in as many as possible. Our organization implemented a sexual policy within the HR policy. We started the process years ago. What we need now is to be consistent with with training. Yes, we agree, Marcia. The policy having been put in place, we need to have ongoing training. And I like the point that was made, the post-care. I think, Nicole, you made that point, the follow-up. Who made that? Yes, it was Nicole. The follow-up care and counseling for the victim. I never thought about that before. I thought that was a very well-made point.
Yeah, I think it again. You go back to what I would call first principles. What's the goal here? The goal is that you want to have a healthy and safe staff. And if it is that that's your goal, then you have to think that you have to protect both their physical and their mental well-being, because at the end of the day, that can quite possibly affect your bottom line. Going back to the issue, Emil spoke about it, this matter of a statute of limitations. One of the in our act, it's 1 year, but one of the reasons that the discussion becomes a little challenging is because these things tend to, one, happen in secret, two, tend to be he said, she said, and so there are evidential difficulties. Three, they tend to represent a particular power dynamic within the organization, which has the natural corollary of causing people to take some time both to process what has happened and then make a decision to report it, because the person who is reporting has to think to himself or herself, what is going to be the result when I make this report? Am I going to lose my job? Is there going to be retaliation? And so on. So when it is that we're contemplating a time frame in the policy, now remember, from the criminal aspect of things, there is no statute. If you rate me 10 years ago, you rate me 10 years ago, I can still feel it today. Sexual harassment, quite frankly, can possibly have a similar effect. But does that mean that the limitation ought to be 10 years? No, because you don't want to necessarily leave a perpetrator hanging and you have other issues. So I do want us to kind of think about that. And going back to your initial question, it is for those reasons that counseling becomes so important, because at the end of the day, you want to have a productive employee that is not so distracted by what has happened that they can contribute as effectively as possible to your organization. So once the company can afford it, I'm not suggesting that it's mandatory, but once the company can afford it, it is helpful and it is desirable.
Yes, yes, definitely. And the point that you just made about leaving a perpetrator hanging out there, the Angostura case in Trinidad, where it was the chairman who was sexually harassing a member of senior management, and eventually he had to step down. And I think it eventually came out that this was not the first time. So persons where they've got away with it before tend to become serial perpetrate, do this on a serial basis. Now, I'm not sure I'm understanding Basil's question here at all. In some jurisdictions, after he complimented you, Nicole, it gone to his head. In some jurisdictions, the posting of certain companies' calendars at an employee's workstation would be considered sexual harassment. How do you propose we treat with such matters? So posting the company's calendars at an employee's work, Nicole, you understand, Basil, you better explain this one.
I don't know if it's the company's calendars that he means or certain calendars, if you think about it.
Posting of certain companies' calendar. The ones with the sexy girls and
Yes,
so what
take
you
them
got to go.
down, Basil. Simple.
Right, you got to go get somebody's calendar to post at somebody else's worst state. That is trespass. That is all kind of things.
Easy answer. I don't know if Emil has something to add, but the answer is quite clear.
Well, what it would be interesting is that if it is that you work for that company, and that company's calendar has the, you know, suggestive figures, and you are putting your own company's calendar up. Now,
At somebody else's station.
well, no, it would, well, presumably it should be by your own workstation, because you should not be moving around something at anyone else's workstation.
He's putting it at somebody else's station, or this person that Basil is referring to.
That sounds like an oddly specific situation. Very oddly
That sounds
specific.
too close to home, Basil.
Yeah, that's an oddly
To me,
specific
it's the same
situation.
as it's a similar thing as sending an inappropriate email, quite
Yes.
frankly. It's moving from me to you. And if it is that it has moved from me to you and I find it to be inappropriate, just like the case I mentioned with the pornography, it's just, if I find it offensive, I don't necessarily want somebody's bottom in my face beside me when I'm working. And that can happen. I don't want that. So, I mean, for me, that's fairly clear, to be quite honest with you.
Yes, yes. I don't think that should be done at all.
Yeah.
Then Marcia says a disciplinary code is a good start, but flesh it out more so it can be clear and accountable than training. A lot of times when it's not clear in policy, the HR hands become tied to execute disciplinary actions. And that is the case wherever there's lack of clarity, because people try to dance between raindrops and then they get bright lawyers like Emil to defend them. Is there a reporting flowchart template which can be shared that can be used as a guide to create our own reporting structure? It's a fairly simple process, but would either of you like to take that? A reporting template that you would just want to quickly run through?
Well, I don't have a template, but usually you want to just have, it's very company specific, but usually your first port of call is always HR, because they're trained to address issues like this. If, as in the example you gave, Camille, it's HR is the one who is the perpetrator, you would then have a mechanism to go either around or outside HR. So say, for example, if it is CEO, usually there are concerns about reporting to HR because HR reports to the CEO, right? So you would then need to look at the board, right? So
Yeah.
again, it's very specific to your company structure, but what you want is to have avenues outside the the usual, I said HR reporting environment. If it if the perpetrator is from HR or someone to whom HR reports to, and you can understand that discomfort there, then it should be you should have an avenue to report above and outside that stream of command, as it were.
Definitely. And many boards have not only audit committees, but now many boards have HR committees. So the policy should really set up a structure that would allow, for reporting outside the organization if necessary. I was in an international organization. We had a hotline that was answered externally. So, but everything is dependent on the specific organization and your means. What I do find important though is that even if you're a small organization like the one I was telling you about, if that little receptionist reports it to the boss needs to do something about it, not just say, I saw him stay, right? That's the change that we want to happen. And Mitzi is saying was actually leaning into the question of what action could be taken where there is no policy. I think we addressed that. And Marcia said HR can execute, just ensure the policy is clear and due process is observed. So yes, clarity is necessary. This organization does not tolerate sexual harassment. We describe sexual harassment as such. Is sexual harassment gross misconduct? If yes, the employee should be dismissed from the first offense. That's Rachel coming out strong there.
Is that an
Which of
opinion or a question?
So the question is sexual harassment gross misconduct? And then she says, if it is, then the employee should be dismissed from the first offense.
Well, as I've said in my presentation, sexual harassment is a spectrum, right? So there can be sexual harassment that can amount to gross misconduct, a la Nicole's case of the rubbing your hand on the calves and company kisses and whatever. And then there can be sexual harassment of you look nice, which conceptually could be harassment, but is not sufficient to justify dismissal. So I
Yeah.
don't think you can say every act of harassment, even if it is found to be harassing, would amount to gross misconduct. So some might and some might not.
And Nicole, I've been so enjoying our conversation. I didn't even notice it's now 11:03. Let me give you some last words, and then Emil, you, and then we will wrap up.
Very quickly, I'm happy that there's so much conversation around this topic. I'm happy for the questions that have been elicited and so on. I would just encourage us to go out and act. I think we're armed with some good information. I think if more information is needed in another presentation can possibly be done. But I would just encourage us to try and either institute our policies or improve our policies if they exist already as best as we can. Do not ignore the matter. As I said in my presentation, the fact that the legislation does not exist does not mean that organizations cannot be held culpable, nor does it mean that organizations ought to ignore the matter. I believe that organizations have a responsibility to address this issue and ensure that the rights of their employees are taken care of with a view to making a sound work environment where people will be happy to work for you.
Thank you, Nicole. Thank you so much. Emil, closing comments.
I would say, again, one of the things I've maintained all throughout the presentation is sensitization, communication.
Mhm.
Don't seek to address this in what I call a militaristic way, right? You're calling the lawyers when you need to, but really your first port of call to address this is sensitization. Camille started out by saying this is a national conversation and issue. Sometimes it can start with the workplace. If an individual has never had any training about how to interact with members of the opposite sex, some instances same sex, um, then and they get that training at the workplace, that perhaps can help to assist them in how they interact with a broader populace as well, And so I encourage everyone, I said, to train, to go to the right trainers, and also to um, again, engage in a continuing education process. It's one of those things where we know that it tends to be, I think Camille had adverted to this, where you have repeat offenders. So just as how in instances of violence, he may start out with one box, as they would say in Jamaica, and then he might move to kill someone. Right. You want to cut it off at the one box stage, right? Before certainly before it gets to that, in terms of an analogy. Cut it off, take that zero tolerance approach, and try and keep it out of being kind of legislated as much as possible. And also bearing in mind that no one is automatically guilty. A complaint does not mean that the person did the act. That's true in criminal law, that's true in civil law, that's true in any environment that you engage in. I'll close with
Hi, good morning. What kind of soup you have today?
We, we're letting you
Green
go for
peas. All
lunch
right, thank
now,
you.
Miss Whitby. All right.
red peas with a little bit of boiled dumpling. Right. Now, I'll simply close with this example. I think my good friend Carla uses where, husband and wife, the husband sends the employee into the safe to get something. The wife comes in when the husband has gone out and says to the employee, aha, I catch you, I knew you were thieving from a long time, and fires them immediately. On the face of it, the wife sees an employee in the company safe. But if they don't inquire, if they don't ask, then they would immediately jump to a conclusion without making the inquiry. So the inquiry is what's important there, where you have to ensure that you ask questions in the right way, not like you did it, didn't you? You know. So another seminar may well be how to actually investigate properly, because that is just an art by itself. Or it's been said that you did that, and so you agree, again, there are ways in which to ask questions that don't result in perhaps a belligerent or defensive response, and be sure to protect the reputations of everyone until there's been a determination as to guilt or innocence. Thank you.
I'm
Thank.
sorry to interrupt. I have one important question.
Okay.
In the
Quickly.
event that a company they have written a policy, however, there's a union on board, therefore it cannot be implemented without the union giving the okay. While the company is waiting for the union to go ahead and review the policy, what if sexual harassment occurs during that time? How does the company address it?
I think the union should move with alacrity so that we're not talking about any long period here, because they don't have any interest in their unionized members being subject to this without redress. Emile, quickly, or Nicole, quickly, because we're way out of time and they're going to fire me and I won't get to moderate again.
Well, very quickly, I don't believe actually the unions have the right to dictate policy like that within the company. They
True.
have the heads of agreement speak to things like benefits, terms and conditions, work hours, and so on. Things like a sexual harassment policy. I don't actually think a union needs to sign off on your sexual harassment policy, because a company has a right to govern its affairs. And once it is that it is an objective policy, is not saying that only the union members are subject to it, then I cannot see where the union actually has a right to sign off on it. That may be contentious, but that's my view.
Yeah. Well, thank you
So,
for that.
until the policy is in place, you cannot, of course, thing. But if you put it to the union, they're taking too long. I personally think you can institute it.
I concur.
Yeah.
And we are getting lots of commendations from Raymond, from Teresa, from Angie. Excellent session. Thanks to JCC. Very informative. Ladies and gentlemen, I think this is a third presentation on sexual harassment that has been done by the JCC. We are trying to bring to our membership and to the wider community guidance on the issues that are important to us all as business people. I want to thank our excellent presenters today. They have done so well. I have learned, we have all learned from you, Emile and Nicole, and we really thank you for taking the time and the effort to be with us this morning and sharing with us as clearly and practically as you have done. Members, thank you so very much for joining us this morning. We had 200 and odd persons, I think, at 251 people.
We had close to
So,
300 at one point. We had 292 at one point.
wow, I missed that. So it clearly was information that persons wanted. And we want to just say, have a wonderful rest of the day. We want to thank Andrea Waite at the JCC for doing their all logistics and bringing us all together, and all the other JCC staff members who participated. So thank you, ladies and gentlemen, and have a good rest of the day.
Thank you, Camille.
Thank you, Camille.
Bye.